Bien, mesdames, messieurs dans la salle, mesdames, messieurs en ligne, bon après-midi, and will switch to English for the benefit of our lecture.
If you just, I'm fine, I can understand that.
Oh, great.
And you have to present in English.
Alors, bonsoir ou bon après-midi plutôt, et bienvenue à cette conférence organisée par le CRDP intitulée Section 15's Haunted House. Cet après-midi, nous avons le plaisir d'accueillir parmi nous la professeure Margot Young du Allard School of Law at the University of British Columbia. Et là, je vais réellement changer pour l'anglais pour lire la biographie de notre conférencière. So Professor Young, as I mentioned, is a professor at the Allard School of Law at the University of British Columbia. Before that, she was a professor at the Faculty of Law at the University of Victoria. She teaches in numerous fields, including constitutional and social justice law. And she was also the director of the social justice specialization at the law school and has organized the Law and Society Speaker Series for close to a decade. She was very kind to propose that I stop there for reading her very impressive CV. If for no other reason, then I'm sure that you'd rather listen to her than listen to me list her a very long list of exploits. And so on that, again, I would like to thank Professor Young for accepting our invitation to come to speak with us here today. As is custom here at the CRDP, Professor Young will give a lecture that goes around 45 minutes or so. And afterwards, my colleague, Professor Karadivan, will take the questions and have a discussion with our lecturer. So without further ado, I will cede the floor to Professor Young. Thank you again.
Merci. Bonjour. It is such a pleasure to be here, although I've been telling anyone who will listen that I have never been so cold in my life as I was this morning, fresh from Vancouver, where it was 18 degrees with daffodils and cherry blossoms. But it's a real treat to be in Montreal. I love coming here, and I'm very grateful for being invited and for the work that has been put into making my visit here possible. Thank you so much. I do want to acknowledge before I begin that we're on land that has long served as a site of meeting and exchange amongst Indigenous peoples, including the Haudenosaunee and Anishinaabe nations. And I want to acknowledge and express gratitude for the stewardship of this land that they have done for millennia. I'm going to talk about a recent equality law case focusing on the Sharma decision that came down in 2022. But I want to begin by noting that equality jurisprudence under Section 15 of the Canadian Charter of Rights and Freedoms travels a rocky road. That's putting it, I guess, mildly. Key decisions issued from the Supreme Court of Canada that set seemingly a clear path ahead, only to be sidelined by the next major case. And we're actually at one of these moments right now. So in 2020, the decision in Fraser in Canada came out of the Supreme Court and generally was received, at least by the people I hang out with in the constitutional law world, was received very positively. It was seen as being a decision that took seriously many of the feminist commentary and critiques of equality law to date, albeit it was also a decision that came close on the heels of a rather fractious time on the court also in terms of equality law. But after Fraser, 2 years later, the court releases its decision in Sharma, and we see that Section 15 analysis is again soundly off course. The judicial authors of the minority decision in Fraser, joined by two judges from the Fraser majority, have come back punching after Fraser. The equality claim in Sharma goes down in a judgment that is thick with the indicia of merely formal equality. And most offensively, this turnabout takes place in a case where the equality harm that the claimant, an Indigenous woman, faces could not be starker. It's a toxic mix of racism, sexism, and settler colonialism. In the paper on which this talk is based, I identify a number of resurgent concepts in the Sharma majority judgment, concepts that are 201 destructive of substantive equality. And I'm calling these concepts zombies. They are the zombie concepts of equality law, notions that refuse to die, despite being long dismissed by many judges and commentators, most commentators indeed. So they're the undead of equality doctrine. They ensure that equality cases under the Charter repeatedly falter, belying any promise of transformative equality actually being securely achieved under Section 15. So the Sharma dissent frames it well. They state that the majority resurrects, and now I'm quoting from the dissent, recently rejected arguments lending credence to the concern that equality claimants must, with each new case, stand ready to defend the exact gains that have been won multiple times in the past. And so my analysis takes up this disruptive paradox of zombies, creatures who are neither truly dead nor truly alive. And I use this as a tactic for examining how some key destructive concepts lurch from one judgment to another under Section 15. So I went to the literature on zombies, and I rely quite heavily on a book called A Zombie Manifesto. It's a serious work of social theory about the history of zombies and how they figure in both political frames and cultural frames. And the authors of this book tell us that zombies have persistent cultural currency and many functions. I'm using them to code equality doctrinal elaborations that are unworthy of the life that the Sharma majority gives them. And I want to say further that much of the jurisprudential restlessness of cases under Section 15 lies at the doorstep of these concepts. Of course, you know, when push comes to shove, really what I'm doing here is criticizing or lambasting yet another decision from the Supreme Court of Canada under Section 15. But I wanted to say something that had a kind of novel twist to it and something that really helps to focus my study of critique of this judgment. And so I'm really concerned with what are the ideas that judges, some judges, can't let go of? And why do these concepts have such staying power despite very convincing critiques of them? And then why pointedly do these zombie concepts appear so strongly in a case where the equality harm at issue is so obvious, that's Sharma, both individually and at a systemic level? And so it's not merely ironic, there has to be something else going on. I think it's deeply revealing of the challenges of seeking transformative social justice through equality rights. So I trace in the Sharma majority three concerns: causation, negative rights, and arbitrariness. And I say these concepts plague equality law, and I'm using the device of the zombie to map their problematic haunting of charter equality jurisprudence. Finally, in the conclusion of these talks, I'm going to toss the idea of zombies aside to engage more directly with the question of what these zombie concepts really are placeholders for. What are they about in language other than simply zombie language? And at this point, I'm going to turn to the specter of judicial activism, which is a related monster, exploring whether or not what we have here is simply a separation of powers analysis gone awry, if that's truly what haunts the Sharma majority judgment. Okay. Let me just give a brief summary of the Sharma decision first. Sharma was an Indigenous woman. In 2015, Cheyenne Sharma pled guilty to charges under the Controlled Drug and Substances Act for importing almost 2 kilograms of cocaine. Ms. Sharma was a single mother. She was behind in her rent. She was facing eviction, and she accepted her partner's offer of $20,000 to bring in a drug-filled suitcase to Canada. Ms. Sharma sought a conditional sentence that, if granted, would have allowed her to serve her sentence in her community rather than in jail. However, amendments in 2021 to the conditional sentencing regime stipulated that conditional sentences were no longer available for the offense of which Ms. Sharma was convicted. Ms. Sharma then claimed that her ineligibility for a conditional sentence disproportionately affected her as an Indigenous woman, particularly given the impact of and the rate of incarceration for Indigenous women. Her Section 15 claim then was an adverse impact claim that a facially neutral law, the repeal in certain circumstances of the availability of a conditional sentence to the sentencing judge, that repeal disproportionately disadvantaged her on the basis of race. So Sharma's an adverse effects case, and there's much preoccupation amongst scholars theorizing about what moral or political concerns animate indirect as opposed to direct discrimination. Canadian courts largely skip this discussion, unlike courts, say, in the US or the UK, but it's not really a focus of commentary in Canadian jurisprudence, and I'm going to follow that pattern. So I'm not really going to talk much about more abstract understandings of adverse impacts discrimination, but I am simply going to note that recognizing adverse impacts discrimination is, I think, critical to appropriately extending the scope of equality law, but it's not without controversy. Okay, let me talk now about the central conceit of my paper, that the majority decision in rejecting Ms. Sharma's equality claims deploys a variety of zombie concepts. First, let me talk a bit about zombies. The zombie's been described as, quote, culturally promiscuous, undead colonial constructs. It is a figure with multiple valences and thus a convenient bogeyman. Is that a bogeyman? Does that translate sort of, you know, it's a convenient kind of villain of fear. And the Zombie Manifesto tells us that zombies are actually everywhere. They're in cognitive science, they're in neuroscience, they're in computer science, they're even in the natural world, where if you dig around in National Geographic, you can learn about zombie ants infected by a parasite that eats their brains. So we've got the notion of zombies is a common concept, and we're told that it's an ever-evolving metaphorical vehicle. Undead chameleons, lumbering from context to context. So why not in law? Actually, the notion of legal zombies is not new. Zombieism appears with perhaps alarming frequency in different strands of American legal scholarship. So in the paper, I go in and talk a bit about how legal commentators in the States talk about various ways in which laws or judicial judgments become zombies. But an example is the way in which the term is referred to statutory remainders, laws that have, despite being found unconstitutional, still remained on the books, only to reemerge when their constitutional status changes. And you only have to think of those state laws outlawing abortion that were unenforceable and irrelevant until Dodd's brought them back into life, and they now have force in the particular state in which they exist. So the notion of zombies being applied to law is not unique to Canadian equality law, although I'm using the term a bit differently because I'm talking about concepts that are active, that come around and appear intermittently in judgments as opposed to lie quiescent suddenly to be reactivated. And so these concepts have yet to really settle down. Theorists describe zombies as ontic objects. They have materiality, their body, albeit it's a rotting and diseased one, and they also have a symbolic presence. The ideas or conflicts that animate them, that haunt thought. Equality zombie concepts, my invention, engage the same tension. Their impact on equality law results in real and embodied consequences for equality claimants because the sentencing judge denied Sharma's charter claim. She served her sentence in prison, not her community. And these concepts also haunt analysis. They shape thought, even in those cases, as I'm going to talk about, where equality rights triumph, not merely then in cases like Sharma. Now, for post-humanist theorists, zombies stand in for a myriad of cultural anxieties. So zombies, for example, they cannibalize opposition, they provoke fear, they encode disease, and in myth and folklore, zombies are decaying threats to civilization. In zombie law, under the Charter, in Charter law with zombies, these concepts are already half-destroyed concepts that shamble on. And importantly, I'm understanding them as menacing outsiders to equality, substantive equality analysis that actually come from within past case law on substantive equality analysis. Now, zombies in culture, for example, in film, are boundary figures. They occupy the border between the living and the dead. Zombie equality concepts are similarly boundary figures. They police the line between formal and substantive equality. And ultimately, I'm going to also link these zombie concepts to anxiety, to judicial fears of what courts and rights run amok might look like. But I'll come to this at the end of my talk. So what do I mean then more specifically by a zombie concept in equality law? Well, I'm giving zombie concepts three features. First, a concept becomes a zombie when it has already been refuted by both judicial precedent and scholarly comment, yet it keeps coming back up in judgments. Secondly, a concept is a zombie concept when it is intelligible from within the history of equality rights, but at the same time threatens to destroy, often on that history of equality claims' own terms, the core potential of equality rights. So I'm seeing them as being destructive of equality from within, making sense within the discourse that they actually destabilize. Finally, zombie concepts are those concepts that scare equality analyses beyond the reach of substantive equality, back into the grip of the individualistic formal equality that was rejected, although I have to say somewhat ambiguously, in the very first Section 15 case, Andrews. Okay, now let me talk about these zombies in Sharma. So Ms. Sharma's circumstances are stark. The dissent provides an overview of both Ms. Sharma's personal history and the larger historic, systemic, and institutional context of her case. And they talk about, amongst other things, and here I'm quoting, the history of colonialism, displacement, and residential schools, and how that history continues to translate into lower educational attainment, lower incomes, higher unemployment, higher rates of substance abuse and suicide, and of course, higher levels of incarceration for Aboriginal peoples. Indeed, really, this context of Sharma seems over-determined in the favor of the equality claim, and consequently, one might think ground too hallowed for zombie insurgents. Moreover, equality and reconciliation should pull in the same direction. Sharma presents an opportunity for the court to demonstrate this, to ensure that Section 15 is responsive to colonialism's historic and current injustice. And yet the majority decision simply declines this opportunity and what seems a very obvious connection between the equality rights of our Charter and commitments elsewhere in the Constitution and in our constitutional framework in general to justice with Indigenous peoples. Brown and Rowe, who write the majority decision in Sharma, give virtually no significance to state responsibility for both the over-incarceration of Indigenous women and the damage that incarceration wreaks on Indigenous women. They say little, a bit, but not much about the life circumstances of the claimant, which are so deeply shaped by the colonialism of the Canadian settler state. Brown and Rowe are, however, quick to begin by stating the test for Section 15.1 from the Fraser majority, and then even more quickly, they condemn the test as not clear. And in offering clarification, these judges summon up the zombie concepts of causation, arbitrariness, and negative obligation to essentially, despite their claim to the contrary, rewrite the test from Fraser. Now, this list, causation, arbitrariness, and negative obligation, could probably be longer, but these are the concepts that importantly scaffold the majority decision. And in this paper, I provide an overview first why they're problematic, how they nonetheless look to past equality analyses, and what they achieve for a majority hell-bent on defeating Ms. Sharma's claim. So let me begin by just saying a bit about causation. Causation is an exemplary zombie concept. Indeed, it manifests in government and judicial arguments in relation to other charters as well. So Section 7 in particular. Reference to this notion of causation in the Sharma majority recalls past equality judgments as well, and in particular, Abella's judgment in the majority decision of Fraser. Now, the idea of causation makes sense, that it's an important consideration. And this is, remember I said one of the features of these zombie concepts is they come out of equality discourse. They're not totally foreign to it, even though they're destructive of ultimately substantive equality. The idea of causation makes sense. Equality is a comparative concept, and an equality inquiry must be grounded in showing difference between the claimant group and some other group that connects with some government action or failure or oversight. So the claimant must show two different things, each of them answering what are the fundamental questions of an equality analysis. The claimant must first establish that there is a distinction based on an enumerated ground, and secondly, that distinction imposes a burden or denies a benefit that has the effect of reinforcing, perpetuating, or exacerbating the disadvantage. And this is simply the well-established two-staged analysis. You set up a distinction that involves different treatment, and then the second question is whether or not that distinction, that different treatment, constitutes discrimination. And I think it's an important piece of the conceptual strutwork of our equality jurisprudence that we have this fundamental divide between difference and discrimination. And the second question is, of course, this idea of does it impose a burden or deny benefit that, say, exacerbates pre-existing disadvantage? That's the point at which different treatment gets transposed into discriminatory treatment. And the majority then is not completely off base to engage with this idea of causation. They're also right that disparate impact discrimination sets a harder task at the first stage. You don't have recourse to a legislative enactment on the face of which differential treatment is apparent, nor, as Abella says in the previous case, Tapotat, is a mere web of instinct, a sort of hazardous guess enough to ground disparate impact. So the notion of causation beguiles. It's attractive. It makes a kind of sense. But too rigid and demanding a demonstration of it can also distort what substantive equality must make visible, a contextual and common sense appreciation of disparity. Majority discusses both of these questions, the first and the second question as the sort of standard test, but it's the first stage, the showing of disproportionate impact, that the claim fails. They write that Ms. Sharma has not, this is a quote, not demonstrated that the impugned provisions create or contribute to increased imprisonment of Indigenous offenders relative to non-Indigenous offenders. The absence of statistically grounded disparity showing that the legislative amendment caused some kind of quantitatively observable difference in treatment was damning for Sharma's case in the minds of the majority. And the majority furthermore credits Abella in the Fraser decision for this application of causation. But that credit or that claim is disingenuous. Abella in Fraser allows for a range of evidence and warns against too rigid rules of what evidence is required. Her concluding statement from that case is clear, and I quote, Both evidence of statistical disparity and of broader group disadvantage may demonstrate disproportionate impact, but neither is mandatory, and their significance will vary from case to case. So the upshot then of this is that regardless of how, I mean, I guess it is important how we think about causation, and it's certainly clear that the doctrinal test from Fraser should have been left undisturbed by the Sharma majority. The majority furthermore adds to this the requirement at the first stage to show that the government action somehow created or contributed to the disparity. And this, combined with the idea for some sort of hard quantitative data, simply allows the equality claim at this stage to be cast off. And this is particularly harmful in terms of those who most need equality. A strict causation requirement will be most unresponsive for those who are most marginalized, that members of the most diverse and marginalized groups face the kind of complex or intersectional discrimination or harm that are going to make it all the more difficult to come up with the kind of hard, concrete data that Brown and Rowe seem to assume must be shown in order to pass this first stage of the Sharma case. That the kind of adverse impact that those most discriminated against or most marginalized in our society face will be more nuanced and lend itself less easily to the capture that Brown and Rowe require. So I want to move on to the second concept. So I've talked about causation, about the idea of adding into the language of Fraser this notion of caused or contributed to, and the requirement of some kind of quantitatively accessible data, which fails in Sharma's case. The second concept, arbitrariness, is a troublesome concept, but I note that it's a zombie with deep ancestry, that it reaches all the way back to the very first equality case, Andrews, where McIntyre wrote, distinctions based on, quoting, based on personal characteristics will rarely escape the charge of discrimination, while those based on an individual's merits and capacities will rarely be classed as discrimination. So this sets the sort of start of a concern with arbitrariness. Abella is also an offender. So in Quebec and A, she talks about discriminatory distinctions being those that have the effect of perpetuating arbitrary disadvantage. Although it's important to note that in later cases, in the recent pay equity cases of 2018, Abella just drops the language of arbitrary, but she too participates in this stringing forward of that initial sentiment from the Andrews decision. Arbitrariness also invokes the idea of stereotypes. And this is a term used in equality jurisprudence to signal those judgments about an individual or a group that are unanchored in actual attributes or features. These are markers then, stereotypes are markers of arbitrary treatment and thus of discrimination. But, you know, just to go back to McIntyre's statement and flesh it out a bit more from Andrews, assumptions of merit or capacity typically also commonly reflect histories of deep systemic inequality. Today's condemned stereotypes were yesterday's common sense. And so at this moment in McIntyre judgment, which Brown and Rowe cite back to, at that moment in McIntyre's judgment, his thrust to substantive equality, which he's very adamant about putting in place for Section 15, his thrust to substantive equality folds back into context oblivious formal equality. I often think of that paragraph out of Andrews as a snake kind of eating its tail, that it really doesn't do what McIntyre wants it to do, and it sets in motion this sort of the stickiness of the idea of arbitrariness for equality claims. But you know what? It's also to say, just like with causation, the idea of arbitrariness is not without some sense. Imposition of burdens or denial of benefits to select groups without acceptable justification is problematic. Substantive equality, I mean, it rests on the idea that not every difference in treatment will necessarily result in inequality, and that identical treatment may frequently produce serious inequality. So there has to be some means to assess when different treatment is not discriminatory or identical treatment is discriminatory. And certainly irrational, irrelevant, arbitrary distinctions drawn by the state that distinguish between groups should attract critical attention. So like causation, the notion of arbitrariness it also seduces. Yet excusing government action from the charge of discrimination, if that action does not appear to be arbitrary, paints with too broad a brush. It risks reliance on assumptions about complainant group characteristics that, as I said before, history has repeatedly shown us can themselves be shaped by discriminatory assumptions. And sometimes distinctions that are not arbitrary may nonetheless perpetuate disadvantage in a discriminatory way. And McLaughlin J., before she was Chief Justice, appropriately complicates the notion of arbitrariness in her judgment in the 1995 decision of Miron and Trudel. She notes that the absence of fit, this is the presence of arbitrariness, the absence of fit between the distinction the government draws and the complainant group features will signal discrimination, but the presence of relevancy, that is the absence of arbitrariness, decides nothing. It's the contextual effect on the complainant that must be the focus, not simply whether the government action is rational, reasonable, non-arbitrary, and so on in terms of what it's doing. And Brown and Rowe, in leveraging and bringing to the fore this notion of arbitrariness, are not attentive to the circumstances of Ms. Sharma and how the removal of the option of a conditional sentence affects her and other Indigenous offenders in the context of colonialism, which is the context of her life, and the context of the dramatic over-incarceration of Indigenous women. Rather, Brown and Rowe look simply to the sense of the current post-amendment sentencing regime to disqualify her claim. And they source Fraser's judgment for this as Abella's judgment in Fraser for this. And so this is a good example of how these concepts I'm calling zombie concepts are not sort of singular free-floating ideas. They are located in past jurisprudence. They're in the majority decision in Fraser where the equality claim was upheld. So they do come out of and are woven into in some way that at particular moments make sense, the history of equality case law. But they do also have this danger that they carry. So Fraser's focus on the circumstances of women in the job sharing program, which was the feature there of the complainant's circumstance, is taken to the sort of looking at the broader scenario and the sense it might or might not make for those women who took the job sharing option, is used by Brown and Rowe along with referencing Whittler, which also opened up the lens to take into account the sort of full range of legislative schemes relevant to the complainant, is taken up by Brown and Rowe to argue that the multiplicity of interests that this sentencing regime that's been put in place in Sharma, that multiplicity of interests actually makes sense in terms of what the outcome is and the effect of it on the discrimination analysis. But they still nonetheless, Brown and Rowe and Sharma, ignore the impact of the sentencing regime on the specific claimant group. That is the harm discretely on the removal of that sentence option for Cheyenne Sharma. And in doing so, and in relying on Abella in Fraser, they ignore Abella's warning in one of the pay equity cases not to sanitize the discriminatory impact, not to sort of dilute it by bringing in broader and broader pictures that essentially wash out or launder out the very specific concrete harm that the claimant is facing. And indeed, the upshot is that Brown and Rowe are deeply sympathetic to the multifaceted and complex policy considerations with which the government is engaged, but they don't show the same sympathy to the plight of Indigenous women in Canada's criminal justice system. And in doing this, we have this conversation about how even with the removal of the availability of conditional sentences, the sentencing judge still has a full range of options available. They ignore the deep significance of conditional sentencing for Indigenous women. And the Indigenous interveners, there were 3 interveners in this case, all of them point out in very stark and moving ways, actually, what it means for Indigenous women to go to jail. Not only in terms of the cultural values, in terms of the removal from the community, impact on them and the community of their removal, but also the kinds of the harms of incarceration that stem from particular attitudes towards and treatment of Indigenous women when they're in jail. So saying that a sentencing judge has the same latitude before and after the 2012 amendments that removed the option of conditional sentencing for the kind of crime of which Cheyenne Sharma is convicted, that statement is just simply factually wrong. And also very much so in terms of the significance for Indigenous women, qualitatively wrong. Now, it is true that arbitrariness is a question that properly belongs most strongly at the second question under equality analysis. So this is dicta on the part of Brown and Rowe because they reject Cheyenne Sharma's claim at the first stage that she hasn't shown actually disparate impact on an enumerated ground. But nonetheless, the discussion is evocative. And it shows that the concept of arbitrariness limps along, suffers on as a potential spoiler of equality sensibility. Now, my last zombie concept is negative obligation. And this is the critique of the rejection of positive obligations under Section 15 by the majority in Sharma it's fairly straightforward. And it's very effectively done in the dissent as well. But it's not surprising to see this insistence on negative obligation alone in the majority Sharma judgment, because this is really one of the most persistent zombies of not just equality law, but all of the jurisprudence on the rights under the Charter. And this is in reference to Section 15, despite the fact that McIntyre said in Andrews that there was a positive right to equality in both the substance and administration of law. So I have a little line about this is the zombie of no positive obligations, this kind of conflicting parentage. It's born in a sense in terms of Section 15 in the first decision where there appears to be an openness on the part of McIntyre to it, but it's also sustained by repeated rejection in case after case, in the circumstances of case after case of the idea of a positive obligation. But Brown and Rowe are adamant that Section 15 does not impose a general positive obligation on the state to remedy social inequalities or enact remedial legislation. And they elaborate by saying simply leaving a claimant in the same situation cannot be a charter infringement. And the dissent makes much of this, arguing how Brown and Rowe have actually forgotten the notion of perpetuation of discrimination, even though they repeat that term itself when they cycle through the test from Fraser, the second stage, exacerbate or perpetuate disadvantage. They also ignore that Sharma is about a situation, sentencing in the criminal justice situation, that has already government's fingerprints all over it. So this is an area definitionally, sharply, deeply defined by government action. Now, there's a connection between the causation element and the rejection of positive obligation, because if governments have only a negative obligation under Section 15, then the causation question also becomes really important, and is it enabled to forcefully defeat a discrimination claim. Without positive obligations under Section 15, where there's no clear evidence that the government caused or contributed to the disproportionate effect, then the government's free to simply leave the inequality in place, to do nothing about it. And just sort of buttressing this conversation is also the fact that commentators on rights within Canada and most sort of other jurisdictions talking about human rights have long defeated the idea that there's a sharp distinction between positive and negative rights. And yet this notion lives on in Canadian jurisprudence. And again, we can see why it does. It's not unattractive for judges. Schooled at a time when it was common to worry about the legitimacy of an overactive court armed with a charter, understanding equality rights negatively puts a cap on what Section 15 might require courts to do. Okay, let me switch now just to my concluding discussion. How much do these criticisms matter? Well, clearly they haven't mattered much, one might say, because everything I'm saying here, I've said before. In fact, I'm a bit of a zombie myself. Like I won't rest with having made these criticisms already multiple times. I'm resurrecting them again and again. So really one wonders, how much does critical doctrinal engagement matter? I mean, after all, you can't argue with zombies. The Zombie Manifesto tells us that. And just to translate it into this context, I don't think you can defeat zombie concepts by reason alone. But it's important when you see this kind of forceful yet problematic resurgence of these notions to ask, what roils beneath the textual or conceptual surface? Now, I've used the metaphor of zombies to kind of capture the persistence of these ideas, to try and convey the notion that they're kind of half dead, like they're limping along, but nonetheless, they're of telling power. But it is also important for me to acknowledge that metaphors can be, I mean, I hope, illuminating, but they do ultimately wear thin. Their literalness, which is key to their effectiveness actually, is still too narrow a portal to get the kind of full nuanced analysis you might want. I mean, metaphors work because they hide some dimensions and emphasize others. And I think this is true of me framing these problems with equality jurisprudence in terms of resilient but destructive zombies. The fit inevitably is not perfect. So let me just throw the notion aside for the moment and essentially turn the idea of sort of empty, soulless zombies on its head and argue that there has to be something really substantive behind their multiple reappearance, other than simply mindless reproduction. And the question then is, what's at stake for judges in Sharma's majority? Why, for example, did Wagner and Moldaver jump ship from the Fraser majority, of which they were a part? I mean, Brown and Rowe and Cote were never on board with the Fraser majority, but Wagner and Moldaver were, and now they're over here, actually essentially pretty much recasting what they signed on to in a case just 2 years before. And there's some revealing bits in the decision and bits more largely that we might talk about. So repeatedly, we see reference to the primacy of democratic legislative decision-making and choice. And Brown and Rowe and Cote have, over many of the past equality decisions, ones in which primarily they were in the dissent, but not always, made these references saying that the turn to the ballot box is really what this claimant should be doing. That equality claimants should take their cause to the polls. And behind this then, of course, is this idea of the separation of powers as it structures the Canadian state. And this idea of the separation of powers, the principle provides a sort of grammar of legitimation for each branch of government, and more specifically for the kind of discussions that these reviewing courts have, what they can do and what choices they should leave to the legislative branch. And we've seen with the advent of the Charter that the Constitution asks courts to do a bit more, I think, that they have to really straddle an uncomfortable line, all the more obviously so in their tasks of judicial review under the Charter. And the concern is that judges neither supplant the legislature, but also not abdicate their role in rights review. And in other pieces I've written about judges being too conscious of backing off and leaving space for the legislative branch, ignoring that the separation of powers is also a positive charge to them to do what the Charter asks them to do. And that occurs often in preliminary motions to dismiss. We see just too one-sided a notion of the separation of powers, this concern that scope be left for the legislative branch, and really abdication of what the judicial branch is asked to do. But I think in Sharma, we can see some other things that are important. So for the dissent, there's a way in which the context in Sharma, that's where I'm going with this, really matters, but it matters differently for the dissent and the majority. For the dissent, it's the backdrop of colonialism and the history of Indigenous women in the criminal justice system that is telling. And when they look at the legislative picture, they put together the provision that requires a GLADU review for the sentencing judge with the provision that removes conditional sentencing as an option. That's the nugget that they're examining. For the majority, there's a different context. For the judges in the Sharma majority, they focus on the adverse impact nature of the claimed discrimination and the fact that the sentencing option that is removed was always only ever a remedial option, conditional sentences. And it's the remedial option that the government put into place that they've now withdrawn for Sharma in the circumstances of her particular offense. So they see the government at action differently. And it's more complex for them because it involves the repeal of a remedial benefit, not simply the institution of a burden. And so it's this context of an adverse impact case, but also one that targets the repeal of an ameliorative action, I think, that explains why Wagner and Moldaver cross over and why the majority is compelled to rework the test from Fraser. They focus on the policy issue in terms of the whole system, but ignore that within it, there's this critical connection between the GLADU obligations and the repeal of conditional sentence, which alternatively, as I said before, is the focus of the dissent. Now, there's one other thing, and in a sense, it's kind of, think of it as the elephant in the room, that could it be that we see this concentration of zombie concepts in Sharma as a kind of, here's another metaphor, extinction burst. That is a temporary escalation of already disavowed phenomena in the face of basically those phenomena having, being appropriately no longer credited. So let me explain this a bit more. We have seen progress in understandings, including judicial understandings of social justice concerns. So the notion of over-incarceration, colonialism injustice, and gender inequity. We do have more articulatedness in commentary and in courts about those problems. Fraser advanced, I think, a better understanding of the transformative potential of substantive equality. So is this majority judgment in Sharma a kind of reaction or response to it? This gets paired with what is observable for at least some of the judges in the Sharma majority, and that is the kind of straightforward hostility to the notion of substantive equality. Simply, Sharma's majority is less enthusiastic about the take-up of a substantive equality analysis. And in fact, we see in some other cases that Brown, although concurring in a set of reasons, also is critical of the extent to which substantive equality is elaborated and relied on in those reasons. So it's hard not also to put this in as a factor for why these concepts, which are limiting concepts, come up and get given more play. So go back to zombies. I said I would leave it behind, but I'm not going to. Zombies, in the commentary on zombies and how they play out in different cultural contexts or literary or, in films and TV shows even, they often are figures instantiating and finding a kind of rear ground effort to protect historic systems of power and oppression and the dominance of patriarchy. So, as I remember, I said zombies were chameleons. So there's a whole discourse that comes out of Haiti about zombies as actually figures of liberation of slaves come back to life to fight slavery. But there's also a more recent understanding of zombies as the kind of remnants of systems of dominance that are being dismantled. And so in these, zombie apparitions are, they're not just sort of ravenous somnambulants, so hungry sleepwalkers, but they're also sort of creatures foretelling that if they're left unchecked, we're going to go into a monstrous future. In these contexts, they uphold a resistance status quo. And so there's a nice resonance then between this, the way that zombies play out in this cultural context, and what I'm saying about the majority judgment in Sharma, that it's really a kind of, is it maybe a rear guard action to preserve a kind of status quo understanding of equality that increasingly court decisions are pushing us away from. I'm open to the criticism that's just too literal and simple an understanding, but I want to leave it out there because I think there's something kind of provocative about it. Okay, so to conclude, the resilience of the zombie notions that I name and their resurgence in Sharma ask us to think hard about judicial review, about equality, and about the Canadian state at this particular moment. Ideas of causation, arbitrariness, and negative obligation, as the Sharma majority deploys them, are unlikely to shape the vision of Section, or unlikely to shape the kind of Section 15 doctrine I want. Jurisprudence that stands as a beacon to a better transformed future. But, equality analysis is malleable. And we've seen these notions be used in judgments where the equality claim succeeded. I cited back, and Brown and Rodew, to several of Abella's judgments. And it's true that no set of rules or kind of insistence on a staged process of interrogation of equality claims is going to make a court's Section 15 jurisprudence safe from the sort of contamination that I chart in the Sharma majority. And to go back to zombie fiction, which actually before this paper I really didn't have anything to do with because I'm very squeamish and I'm just not good with violence or scary things, and I watch really saccharine, like simple shows that my partner scorns me for. But in zombie fiction, what, in terms of tales of zombie invasions, it's vigilance and leadership that win the day and defeat the zombies. So our context is a little less dramatic than these shows, but maybe in the less dramatic context of academic commentary, we need equal alertness to the analytical threats that these ideas present and the ways in which they persist. Thanks.